Doc Talk. Yeah, we keeping it smooth. Your favorite paralegal got the legal groove. From the stars in the courtroom to your cousin's case, we breaking it all down. No rush, just pace. Hey, it's the girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Hey guys, so I'm back and I want to go over, I want to talk about the jury. If you watched my 3.5 hour live, hopefully you guys were able to see the all of the evidence that was used in the Carmelo Anthony's trial, from the photos to the 911 audio calls to the video from all angles. What we concluded, or at least I concluded, based off of what I have in my possession, is that based on the videos, you really cannot tell what happened under the tent. All I saw was movement. I seen an individual exit the tent and ran, and then everybody else started running. Without having any knowledge of what happened under that tent, it's really hard to try to draw any conclusion or make an inference of what happened. And this is just me seeing what I have, that I'm able to see the tangible evidence. The jury, however, not only had access to this information, but they also had access to the witness statements, the individuals that went on the stand. Those were the individuals that were under the tent with Karmelo and Austin. They are the individuals that know exactly what happened. In the 911 call, we did hear, a lot of stuff that was going on in the background. The 911, uh, I don't want to say analyst or specialist, but the 911 operator asked, where is the suspect? Do you know where he is? Did anybody know him? And you can clearly hear one of the individuals saying that nobody knew who he was, and that contradicts what was actually said. And I'll get to that information in a second. But back to the jury. The question is, did the jury do their job based off of what they were instructed to do? How does a jury know what to do? Before we go to trial, we have what's called pretrial documents, exhibit list, witness list, um, everything that you could think of, plus what's called a jury charge. And the jury charge is something that both counsels, the defense and the state, will submit to the court. The judge will review, and if everything looks good, he will sign off on it. And that is what is sent over to the jury once they start their deliberation. The jury charge includes instructions and definitions that they need to follow and use in order to determine whether or not the actions of an individual, whether they're guilty or not guilty, based off of everything that was presented in court. Okay, I want everybody to understand that. So what I'm going to do, first and foremost, we're going to look at the jury charge. If you did not have an opportunity to catch the live, it's fairly long, but go ahead and watch it, because I didn't want anybody to say that I wasn't playing the whole video in its entirety or anything of that nature. Please go watch that. I also talked about, my experience. I've never had like a horrible experience in Collin County. I just choose not to live in Collin County, and I took my kids and we moved to Dallas County, where I feel it's more diverse, it's fair, and it's just a better environment versus having them grow up where we were constantly, questioned or looked like we didn't belong there. But that's neither here nor there. Let's get to the jury instructions. So, Mr. JD Miles is a news reporter in the Dallas Fort Worth area. So, I did choose him to get all of my information from since I was unable to make it. It's something I wanted to do, but unfortunately, during that time, I had discovery due in a couple of cases, and I had to get that to the attorney. So I can't jeopardize, his cases because, not saying Carmelo Anthony's case was not important. I had an obligation to these attorneys to get this discovery done. But going to this, I choose Mr. JD Mouse because he was there from the beginning into ending, and he actually took a good account of, what happened and was able to update the public on that. So I do thank him for that. But we're going to go ahead and we're going to uh, use his account to see, everything that went on. The first and foremost, what I want to read is the jury instructions. Like I said, these are instructions that is given to the jury that sets forth what they need to do, what they can consider, what they can't consider, so on and so forth, as well as the what was I trying to say? But just the definitions in case they was unsure of what a term meant. It was listed in these jury instructions. So I'm going to read it to you guys, and so you guys can get a better understanding of what was required of each juror. And then we're going to go and look at the different things that was said from the witnesses, as well as, and I'll start at the beginning. I'll start when they was doing jury selection, why, some jurors was elected and some not. All right, so here's the jury instructions. It reads, members of the jury, Carmelo Sincere Anthony, the defendant, stands charged by indictment with the offense of murder alleged to be committed on or about April 2nd, 2025 in Collin County, Texas. To this charge, the defendant has pleaded not guilty. The law requires that I submit the following instructions to you in this case. These instructions contain all the necessary to enable you to reach a verdict. If any evidence was presented to raise an issue, the law on that issue must be provided. You are to read these instructions as a whole. The law applicable to this case is as follows. So, presumption and burden of proof. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The law does not require the defendant to prove his innocence or produce any evidence at all. The presumption of the presumption of innocence alone is sufficient to acquit the defendant unless you are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in this case. The burden of proof in all criminal cases rests upon the state throughout the trial and never shifts to the defendant. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. If the state fails to meet its burden, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. Terms and definition. Bodily injury means physical pain, illness, and impairment of physical condition. Deadly weapon means anything that, in the manner of its use or intended use, is capable of causing death or serious bodily injury. Individual means a human being who is alive. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement or protracted loss or impairment of the function of any bodily member or organ. The offense definitions. A person commits murder if he intentionally or knowingly causes the death of an individual. A person who commits murder if he intends to cause serious bodily injury and commits an act clearly dangerous to human life that causes the death of an individual. or a person who commits manslaughter if he recklessly causes the death of an individual. Mental state definitions as to murder. A person acts intentionally or with intent with respect to the result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to result of conduct when he is aware that his conduct is reasonably certain to cause the result. Murder. Now, bearing in mind the foregoing instructions, if you find from the evidence beyond a reasonable doubt that on or about April 2nd, 2025, the Collin County, Texas, the defendant, Carmelo Anthony, did intentionally or knowingly cause the death of an individual named Austin Metcalf by stabbing Austin Metcalf with a knife, a deadly weapon, or with the intent to cause serious bodily injury to Austin Metcalf, an individual did commit an act clearly dangerous to human life by stabbing Austin Metcalf with a knife and a deadly weapon that caused the death of Austin Metcalf, then you will find the defendant committed murder as charged in the indictment. If you do not so believe, or if you have a reasonable doubt thereof, you will next consider whether he committed the lesser included offense of manslaughter. Mental state definition as to manslaughter. A person acts recklessly or is reckless with respect to the result of his conduct when he is aware but consciously disregards the substantial and justifiable risk that the result will occur. The risk must be of such a nature and a degree that it dis, that its disregard constitutes a gross deviation from the standard of care that ordinary person would exercise under all circumstances as viewed from the actor's standpoint. Manslaughter. Now, bearing to mind the foregoing instructions, if you find from the evidence beyond a reasonable doubt that on or about April 2nd, 2025, in Collin County, Texas, the defendant, Carmelo Anthony, did recklessly cause the death of an individual named Austin Metcalf by stabbing Austin Metcalf with a knife, a deadly weapon, then you will find the defendant committed manslaughter as included in the indictment. If you do not believe so, or if you have a reasonable doubt thereof, you will acquit the defendant and say by your verdict not guilty. So as you could, they were instructed there's three things: either murder, manslaughter, or not guilty. So they had to take the information they had and determine whether it was murder, whether it was manslaughter, or whether he should be acquitted. Okay? If you find the defendant committed murder or manslaughter beyond a reasonable doubt, you will next consider whether the act is self defense. Self defense, deadly force. You are instructed that a person is justified in using force against another when and to the degree he reasonably believes the force is immediately necessary to protect himself against the other's use in attempted use of unlawful force. The use of force against another is not justified. 1. In response to verbal provocation alone, or 2. If the actor provoked the other's use or attempted use of an unlawful force, unless A. The actor abandons the encounter or clearly communicates to the other his intent to do so reasonably, believing he cannot safely abandon the encounter, and B. The other nevertheless continues or attempts to use unlawful force against the actor. Then we have a person is justified in using deadly force against another. 1. If the person would be justified in using force against the other, and 2, when and to the degree the person reasonably believes the deadly force is immediately necessary to protect himself against the other's use or attempted use of unlawful deadly force. A person who has the right to be present at the location where the deadly force is used, who has not provoked the person against whom the deadly force is used, and who is not engaged in criminal activity at the time of the deadly force is used, is not required to retreat before using deadly force, and the finder of fact, when determining whether the actor reasonably believed that the use of deadly force was necessary, may not consider whether the actor failed to retreat. Where there is more than one assailant, the defendant has the right to act upon the hostile demonstration of either one or all of them, and to assault either one of them if it reasonably appears to him that they are present for the purpose and acting together to take his life or to do him serious bodily injury. Reasonable belief means a belief that would be held by an ordinary and prudent person in the same circumstances as the defendant. Deadly force means that it is intended or known by the person using to cause, or in the manner of its use or intended use, is capable of causing death or seriously bodily injury. You are further instructed that it is your duty to consider all relevant facts and circumstances surrounding the alleged killing and the previous relationship existing between the accused and the deceased, if any, together with all relevant facts and circumstances going to show the condition of the mind of the accused at the time of the alleged offense. Now, therefore, hearing in mind the foregoing definitions and instructions, if you believe from the evidence beyond a reasonable doubt that the defendant in Collin County, Texas, on or about April 2nd, 2025, did commit murder or manslaughter, but you further find from the evidence or have a reasonable doubt thereof that the defendant reasonably believed that the deadly force, when and to the degree used, if it was immediately necessary to protect himself against the use or attempted use of an unlawful deadly weapon by Austin Metcalf or others with him, you will acquit the defendant and say by your verdict not guilty. I hope everybody got that. So they're saying that if he found that, if pretty much if Austin or any of the people that was under the tent, if he had to use a weapon, deadly weapon, because he saw another deadly weapon being used by either Austin or one of them, then of course he would have the right to defend himself. And if that was the case, then their verdict would have been not guilty. Okay. You are further instructed, however, that if you believe from the evidence beyond a reasonable doubt that at the time and place in question, Austin Metcalf or others with him were not using or attempting to use unlawful deadly force on the defendant, or that the defendant did not reasonably sorry, believe that his use of deadly force was immediately necessary, then you will find against the defendant on his plea of self-defense. In deciding whether the state has proved that the defendant did not reasonably believe his use of deadly force was necessary, you must consider any failure of the defendant to retreat that might be shown by the evidence. If you find both: one, the defendant did not provoke Austin Metcalf, the person against whom the defendant used the deadly force, and two, the defendant was not engaged in criminal activity at the time he used the deadly weapon. If you do not find both, one and two, you may consider any failure of the defendant to retreat that might be shown by the evidence in deciding whether the defendant reasonably believed that the use of deadly force was necessary. If you find and believe from the evidence beyond a reasonable doubt that the defendant immediately before the difficulty did some act, used some language, or both with the intent to produce the occasion to bring on the difficulty and kill Austin Metcalf, and that such conduct was reasonably calculated to and did provoke a difficulty, and that in response to this provocation, Austin Metcalf attacked the defendant, or reasonably appeared to attack him or to be to attack him, and that the defendant then killed Austin Metcalf in pursuance of his original design, if you find there was such, or produced a necessity for taking the life of Austin Metcalf, you will find against the defendant's claim of self-defense. Evidentiary instructions. At times throughout the trial, the court has been called upon to pass on the question of whether or not certain offered evidence might properly be admitted. You are not to be concerned with the reasons for such rulings and are not to draw any inferences from them. So, meaning that, if they say, well, can we enter this into exhibit? And they say no, as a juror, you can't be like, oh, okay, they didn't want to, submit that into evidence. We need to take that in consideration, whether they're trying to hide, so on and so forth. What the court is saying, that's not your concern. And you don't need to know the reason as to why we say that evidence cannot be, you know, entered into evidence. So that should not, so with that being said, that should not be included in your reasoning as to why you are ruling this way. Okay. Da, da, da. Whether offered evidence is admissible is purely a question of law. In admitting evidence to which an objection is made, the court neither determines that what weight should be given such evidence nor passes on the credibility of the witness. As to any offer of evidence that has been rejected by the court, you, of course, must not consider the same. As to any question to which an objection was sustained, you must not conjecture as to what the answer might have been or as to the reason for the objection. Okay. So, if evidence was asked to be submitted in and they say no, or if, the attorney asked the witness something and then the other attorney object, they can't take none of that into consideration when they are determining whether Karmelo was guilty or not guilty. The fact that the defendant has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no interference of guilt at his trial. You are instructed that you may consider all relevant facts and circumstances surrounding the killing and previous relationship existing between the accused and the deceased, if any, together with all relevant facts and circumstances going to show the condition of the mind of the accused at the time of the offense alleged in the indictment. You are instructed that the defendant may testify in his own behalf if he chooses to do so. But if he elects not to do so, the fact cannot be taken by you as the circumstance against him or prejudice him in any way. The defendant has elected not to testify, and you are instructed that you cannot and must not refer to or allude to the fact throughout your deliberations or take into consideration for any purpose whatsoever. Concluding instructions. You are charged that is only from the witness stand that the jury is permitted to receive evidence regarding the case, and no juror is permitted to communicate to any other juror anything that he may have heard regarding the case from any source other than the witness stand. So that's what everything is based off of the witness stand. In deliberating on this case, you are not to refer to or discuss any matter or issue not in evidence before you. Further, you shall not talk about this case to anyone not of your jury. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony, but you are bound to receive and to follow the law from the court. After you have retired to consider your verdict, no one has any authority to communicate with you except the bailiff who has you in their charge. You may communicate with the court in writing, signed by your foreperson, through the bailiff who has you in their charge. Do not attempt to talk to the bailiff, the attorneys, or the court concerning any question you may have. After argument of counsel, you will retire and select one of your members as your foreperson. It is the duty of your foreperson to preside at your deliberations and to vote with you in arriving at a verdict. Your verdict must be unanimous, and after you have arrived at your verdict, you may use one of the forms attached by having your foreperson sign the particular form that confirms to your verdict. And that is all on that. So that was the jury charge. So now you guys can, I hope you can understand what the jury's instructions were and why they ruled the way they did, if that makes sense, right? They had instructions. So it's either manslaughter or it was murder or not guilty to be a third option. But based off of the evidence presented, based off of what the witnesses stated, they had to take all that information and apply it to the language under murder or manslaughter, or if they don't feel that any of it was a factor, then it would have been he would have been acquitted. All right. Uh so let's see. I'm going to start from the beginning so we can exactly see how long, well, how it started. Because the first thing first is you have to select a jury. Alrighty. All right. I don't know exactly what would be first. I'm just going to read it from the bottom to the top. We're going to do that. So the prosecution argued that the three black prospective jurors work as educators and they were dismissed for that reason because their jobs were too connected to the circumstances of this crime. Opening statements are scheduled for 9, and that's when we will also get our first look at the makeup of the jury. So, three black prospective jurors who worked as educators was dismissed because they felt that they would be too connected to what was going on. The judge has overruled the defense objections to exclusion of blacks on the Carmelo Anthony jury. Wow. The judge has overruled the defense objections to the exclusion of blacks on the Carmelo Anthony jury. 12 jurors and 6 alternates have been selected. We do not know the makeup of the jury yet. Opening statements are scheduled for tomorrow morning. Then we have juries about to be seated in Carmelo Anthony's murder trial. Defense is filing an objection to the prosecution using its strikes to eliminate the only 3 remaining prospective jurors who are black. The defense claims it's a violation of law and presenting argument to the judge. Wait a minute. I think I have to reread that to myself. Defense is filing an objection. Oh, okay. I'm about to say I have to reread that. So defense is filing an objection to the prosecution using its strikes to eliminate the only 3 remaining prospective jurors who are black. The defense claims it's a violation of law and presented arguments to the judge. I swear it's like maybe I had to oh, I'm reading. Okay. So it says 100% of the African American jurors who were qualified to serve have been dismissed by the prosecution. Prosecution argues that they thought one of them was Middle Eastern and that the circumstances surrounding the crime were race neutral and should not require a panel of diversity among jurors. Well, I'll be god darn. The judge overruled the defense objections. Mm, okay, so that makes sense. That's the whoo. So 100% of the African American jurors. Hmm. Opening statements. All right, jury has entered the courtroom for the Carmelo Anthony murder trial. If the 18 jurors and alternates, there are 10 women and 8 men. It's a mix of ethnicities: white, Middle Eastern, and Southeast Asian. No black jurors, as we reported yesterday to the objections of the defense. All right. Prosecution opening statements in Carmelo Anthony's murder trial from Bill, Collin County First Assistant District Attorney. This is the individual who was also listed as a defendant in the sexual harassment lawsuit. District Attorney says, who says the defendant brought a knife into the stadium that was prohibited and plunged into the chest, buried it into the heart of another young man, causing his death, and then he ran away. This case has nothing to do with race. This case has nothing to do with self defense. The facts of this case are simple. They are as simple as this killing was senseless. That video tells the story. The video shows the murder. Then you're going to hear from numerous eyewitnesses who were there. This was a provoked, unjustified murder. It is senseless. Now, that was the prosecution's opening statement. And normally, the jurors are not supposed to even consider the opening statements, okay? All right, so this is opening statement from the lead defense, Mr. Mike Howard, on what he says happened in the stadium tent where the fatal stabbing of Austin Metcalf occurred. Everybody in the tent is a teammate and a friend of Austin and Hunter Metcalf. Hunter and Austin notice Melo and tell him to leave. I think he said told him to leave. Melo is 5'8", 130-ish pounds. Hunter and Austin were 6'1", 213 to 215 pounds. You're going to hear different accounts of what was said. He says witnesses will testify that Melo said, "As long as you don't touch me, we're cool." Austin makes the first physical contact. In spite of the warning, "Touch me and find out," or whatever was said. In that split second, Melo has a decision to make: how and when to act. So he reacts in a split second of fear and chaos. He immediately says, "I was defending myself." All right, it says that the jury in the Carmelo Anthony trial is about to watch surveillance video at the Kukendall Stadium that recorded the fatal stabbing. Okay, we obviously looked at that. Let me see what this says. He's saying that the jurors are about to watch the original unaltered video before they watch the enhanced version. The video shows a wide shot of about half of the outdoor high school stadium from the middle of the football field to the parking lot behind the end zone. You can see tents in the top right corner on the other side of the field that were put up on in the lower bleachers. Prosecutors have zoomed in where Carmelo Anthony enters the stadium in a gray sweatsuit wearing Memorial High School tent. Wait, gray sweatsuit near the Memorial High School tent. About 15 students are sitting. Okay, and we've seen that video. We've seen that video. Let's see. He said jurors have watched the first 5 minutes of the surveillance video of the scene before the stabbing. Students gathered under the yellow canvas with the Memorial High School logo that's over the bleachers near the field. Just after 10 a.m., there's some pushing among individuals under the back of the tent, but it's difficult to tell what happened. The camera is too far for the original video to determine. Suddenly, after some pushing, all of those under the tent scattered quickly. The video then shows Carmelo Anthony running out of the stadium less than a minute after the stabbing and into the school parking lot. Even him, the reporter that was in the courtroom, stated that it was difficult to tell what happened. Why? Because the camera was too far for the original video to determine. Now, Video from another camera shows Carmelo Anthony wearing a gray sweatsuit being chased while running near the edge of the stadium, and he is putting his hands up in the air before two uniformed police officers handcuffed him and take him away. The jury is about to see an enhanced version of the video that focuses on the moment before and after the stabbing. Let me see. Court has resumed, and the jury in the Carmelo Anthony murder trial is about to see a digitally enhanced video from a surveillance camera that has never been released to the public. Judges allowing it to be shown on one monitor to the jury, but those of us on the left side of the courtroom room will be able to see it. All right, so here he says the jurors finished watching the enhanced security camera footage during the trial. But so far, these new magnified videos, which have never been viewed by the public, still do not produce a clear visual of what happened under the tent in the bleachers of the stadium where Austin Metcalf was fatally stabbed. You can tell that they were pushing, but it's mostly obscured by other people in front of the defendant and Metcalf. Carmelo Anthony's defense attorney, Toby Shook. Okay, so I guess he would. Oh my gosh. And I think Toby Shook is the same attorney that is doing the Yellow Beezy trial. But he cross-examined the video analysis expert who magnified security camera videos that recorded the scene of the fatal stabbing. He said, "You really can't tell what people are doing under the tent, can you?" And he said, "Yes, sir. There's really no way to determine when an argument starts or stops, is there?" "No, sir. I'm just reading what somebody that was in the courtroom stated." All right. Let's see. Prosecutors called the Memorial High School track coach to testify. Austin Metcalf was on the school's track team competing in a meet. Okay. Da, 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 da. All right. The first prosecution witness in the Carmelo Anthony this morning is Neil Adams, who is a Frisco firefighter who responded to the scene of the fatal stabbing. It says when he arrived, he said Austin Metcalf's pupils were dilated. He was gray, no aspirations, and he did not have a pulse. Next witness was the Frisco police officer, Eduardo Cortez. That is the officer whose body worn camera had the incorrect date on it that everybody's in an uproar about. It says that, let me see, what did he say? He said, "I had the suspect raise his hands in the air. I gave him instructions. I patted him down for any weapons. I advised that I had alleged suspect detained in handcuffs." Carmelo Anthony replied, according to the officer, "I'm not the alleged. I did it. He put his hands on me. I told him not to." Prosecutors are about to show the jury video from the body cam. All right, and we saw the body cam. Prosecutors are showing the jury body worn cameras from responding officers. All right, so 4-minute body cam was played. Officer encounters Anthony, handcuffs him, and sits him down before going through his pockets and frisk him. You hear Anthony sounded like he's sobbing, crying, saying as the officer walks him to the car, "I told him not to put his hands on me." He is then put into the patrol car and gives officers his name and spelling. Another officer's body cam records Anthony saying after the officer radios that he is the alleged suspect, "I am not alleged. I did it." Under cross examination, the defense asked the officer, "Do you remember him crying once you and the other officer are in the squad car?" "Did I see tears coming down his face? I can't testify to that because I didn't see his face. My description was based on the tone of his voice." The defense attorney did get the officer to admit on the stand that Anthony surrendered peacefully and complied with officers' commands on the body cam of the arrest. He's not resisting. Officer said no. Not struggling. Officer said no. Not continuing to run. Officer said no. Jurors are getting the first look at the knife that the prosecutor says Carmelo Anthony used to kill Austin Metcalf. It's a 5-inch folding knife with blood or had blood on it, and it was photographed at the scene on the ground in the bleachers of the stadium. The jury also see photos of Carmelo's backpack, which was near the knife at the scene and had been opened. Prosecutors have now introduced the knife into evidence and the backpack. Let's see, jurors are now watching an extremely graphic body cam that shows paramedics applying CPR to try and save Austin Metcalf's life while you can hear students wailing and screaming inside the stadium from a distance. Inside the courtroom, Austin Metcalf's mother and father each have other family members wrapping their arms around them, and they broke down in tears while watching it. Carmelo is watching the video intently along with the jurors. The video captures the chaos and uncertainty about what happened and why. And based off the 911 calls, that second one, you can hear everybody in the background. For the first time, we are hearing from a state witness to the fatal stabbing. All right, so he was there to run the 800-meter race. He described the scene as he arrived at the stadium and who was there. He entered the Memorial High School tent and says he saw Carmelo inside. He testified that Carmelo was hanging out in the tent. I remember people confronting Carmelo and saying, "You shouldn't be here. You probably should leave our tent." I also said, "You should leave." So prosecutor says, "Was it aggressive?" I didn't think so. I remember it was getting more aggressive. I remember Carmelo refusing to leave and Austin saying, "You need to leave," and Carmelo saying, "Touch me and find out." Austin's track teammate says Carmelo was asked to leave about 15 times. Prosecutor asked, "Well, did anyone try to gang up on him?" "No, sir." Prosecutor asked, "How long did it go on?" He said, "Roughly 2 minutes." Prosecutor asked, "Was Carmelo angry?" Said, "Yes, sir." Prosecutor also asked, "Was Austin angry?" He said, "Yes, sir." Carmelo started refusing to leave. Prosecutor then asked who was provoking. He said, "Carmelo." Austin leans in to push him, and Carmelo stabs him. Carmelo has his hands inside a backpack, and we thought it was a bluff. He says he and others didn't believe Carmelo would do anything because they live in a safe community. Austin fell down the bleachers onto his backpack and he got up. He lifted up his shirt where his chest was all bloody and he said, "I think I got stabbed." Prosecutor, did he say anything? I think he said, "Oh my God." Prosecutor asking about Austin's shove of Carmelo. I wouldn't say it was a light shove or a hard shove. I would say it was more of an in between. Was Hunter involved in any way or any of this? He said no. Witness recreates the moments before the fatal stabbing with defense attorney Toby Shook. He says Carmelo Anthony was seated with his backpack in his lap and his hands inside. Austin Metcalf approaches and is right in front of him. Witness says Metcalf leans in and pushes Anthony by placing his two hands on Anthony's shoulders. Anthony pulls a knife out of his backpack, gets up and pushes Metcalf while at the same time stabbing him in the chest. Metcalf falls back down the bleachers. More current and former high school students are taking the stand today in a Carmelo Anthony's. Okay, well, I'm not going to keep rereading that. Here's some of the back and forth Q&A with prosecutors and defense attorneys. So, Prosecutor Bill, he says, "Was there any reason you saw Carmelo Anthony to stab Austin Metcalf?" No. Prosecutor asks again, "Was KA acting in self-defense?" Witness says no. That's lethal force against non-lethal force. Defense attorney asks, "Did you see Carmelo Anthony before?" Witness says, "I don't remember." Defense attorney said, "Do you remember telling Detective Hunter popped in and defendant Austin?" He says yes. The defense attorney asked, "Do you remember in your written statement saying Austin put his hands on his shoulders to intimidate?" Witness says yes. More of a warning. Actions speak louder than words. Defense attorney says bigger build. Witness says, when you talk about Austin, witness says, yeah, more broad. Defense attorney also asks, he could look intimidating from his size. And the witness says, sure, yes. Another witness takes the stand, a 16-year-old boy who was a freshman at the time of the stabbing. And this is so sad because oh my gosh, my 13-year-old, he's going to the 8th grade. And so when he goes to the ninth grade, they're just babies. They don't know. And they still scary. Well, at least mine's are. Um, he helped us set. Okay, so he was a football and track. He helped set up the tent. So prosecutor says, "Did you see anyone who didn't belong in the tent?" He said, let me see. He said he was from Centennial High School. We told him he had to leave multiple times. Prosecutor asked, "Is the expectation that other teams stay out of your tent?" He said yes. Prosecutor then asked, "When you tell him to leave, what does he do?" Witness says he doesn't leave. He gets angry and tries to provoke us, saying, "Make me leave." Prosecutor says, "Was Austin or Carmelo instigating?" He said, "Yes, Carmelo." That doesn't make sense. So he asked, "Was Austin or Carmelo?" Oh, okay. He said, "Yes, Carmelo." Okay. Um, Defense attorney asks, "When Austin decided to push him out, how did he get him out?" He walked over to him. Defense asks, "Was Carmelo still sitting down?" Witness says, "I think so." Defense attorney says, "Did he grab or push him?" Witness states he pushed him on his shoulder area with both hands. The prosecutor asks what happens next, and the witness states that Austin tries to force him out because we didn't have any other choice. Prosecutor Bill said, "Did Carmelo have his hand in his backpack?" Witness says yes. He then asked, "Describe the push from Austin." He said it was a little push. "Austin Metcalf meant a lot to you?" He said yes. "Have you been in counseling?" He says yes. It was Carmelo Anthony. Was Carmelo Anthony being stubborn, provoking? Yes. "Was this self-defense or murder?" This was murder. Defense took over and says, "When it was raining, it was okay for him to be in the tent." Guess what he said? Yes. "Once it stopped raining, he asked to leave." Yes. The defense attorney is showing cardboard cutout of layout. Witness is saying where everyone was. The defense attorney asks, "Did he talk about what was in the backpack?" Witness says he said there was something in there. Defense attorney says, "You said Eddie called Carmelo Mello." Yes. So Eddie knew him. That's interesting. Another witness. Let's see. Another 16-year-old boy. All right. So prosecutor asks, "Did you become aware of someone not on the team in your tent?" Witness says, "Yes. He sat next to me." Prosecutor asks, did this worry you, bother you, or seem kind of normal? Witness says, it was kind of strange because everyone is supposed to be in their home tent. Prosecutor says, what did Carmelo say? He said he wasn't leaving and says a profanity. He said, what did Carmelo do? He started to get more aggressive. He then asked, what does he say next? F you all, I'm not going to leave. You're a bunch of ussies. Uh, let's see. He was then asked, did Austin take the lead? Witness says yes. Carmelo put his hand in the bag and said 5 times, touch me and see what happens. Austin said he's not going to touch this guy. He was calm. Prosecutor then asks, what did you see during the stabbing? Witness says you saw a big hole and blood coming from his upper body. Prosecutor asks at some point, did you decide to unfreeze and do something? Witness says yes, he had a knife, so we ran to the left side of the field. I heard Xavier say, Austin looks dead. Prosecution calls another witness from Memorial High School, and this person wait, knew Carmelo, Anthony, and Austin, so he knew both of them. Prosecutor asks, what did you notice in the tent? Witness says Carmelo was there. I dapped him up. Prosecutor said, did you talk? He said, just said hi. He asked, did you think it was weird he was in the tent? Witness says yes, because teams are supposed to be in their own tent. I'm assuming everything has changed because when I did track and cross country, well, mainly track because it's at a stadium, we were in each other's tents, talking under the bleachers, hanging out. So yeah, it's a different age and time. I see. Prosecutor asked, "You call him Mello?" He said, "Yes." That right there, if you're calling me a nickname, we know each other. I mean, that's anybody that's like common sense. But anywho's prosecutor, after you stopped talking to him, did you see any other teammates talk to him? He said, "Yeah." Austin said, "Who are you?" Prosecutor asked, "Did you see?" Witness says Carmelo gets mad. Or what did you see? Carmelo gets mad. Wait. Carmelo gets mad. He told to get mad. He told to get out of the tent. Yeah, that makes no sense. Prosecutor asks, once he gets mad, what happens? Witness states, he says, you're not going to move. You're a bitch. Prosecutor says, was Austin starting to get mad? Witness says he was getting defensive. Someone we didn't know was in the tent. He's always leading. He's always protecting us. Prosecutor, after that, witness says, Carmelo said, you have to move me. Austin put his hands on his back. I saw Carmelo hands go in the backpack. We're at a track meet. I wouldn't expect anything to be in there. Carmelo said, touch me. You have to move me and find out. Trying to provoke him. Prosecutor says, then what happens? Witness says Austin puts his hand on him and falls back. Let's see. Prosecutor says, how was Austin trying to move him? Witness says he was trying to move him off his seat, a soft shove. What did Austin do? I see a hole in his chest and blood. He starts screaming for help. When this is going on, who's standing? Before the stab, Austin was the one standing, so everybody was sitting under the tent. Prosecutor, did any kids from Memorial try to gang up on Carmelo? No. You're expecting at most the fist fight? Yes. You didn't think anything was going to happen? No. After Austin falls, where does Hunter go? Hunter went to help him get up, and that's when Austin pulled up to his shirt and started screaming. Prosecutor says you thought the stab was a shove. Yes. What did you see? I saw our coach take off his sweatshirt. Austin fell down and looked unconscious. After the stabbing, where did Carmelo go? I saw him run up the bleachers. The coach heard you saying that was my brother. That was my brother about Austin. He said, yes, sir. So this individual who called him Mello didn't know him. That's pretty much what it said. The state just rested its case in the Carmelo Anthony calling. There was 21 witnesses. Defensive moves to direct verdict claiming the state did not make its case. The prosecutor said it did. Judge says motion denied. So the defense counsel submitted a motion, I'm assuming to dismiss, claiming that the state did not make its case, and the judge shot that down. Let me see. This was the state's last witness in the Carmelo Anthony case. Is the medical examiner. Alrighty. It reads, Chief Medical Examiner for Collin County, Dr. Elizabeth Ventura, says she's done thousands of autopsies and does internal and external examination, sectioning off organs. This came in as a suspected homicide requiring a more in-depth autopsy. She performed Austin's autopsy the day after his death. He was 213 pounds, 73 inches, which is 6'1". His body was received in a hospital gown. Hands, feet were covered in bags. He had a stab wound on the left side of his chest. It penetrated the heart. The heart was removed, and the stab wound gave a measurement of 2.5 gapping in length. The classification is gapping because it broke the fibrous tissue and pulled it apart instead of a slit. The path of the wound went completely through the heart. They are showing four pictures to just to the jury. There are a stab wound to the chest, a close-up image of the gaping oval-shaped wound. The last two are of the heart after it was removed. Several jurors look emotional and putting their hands over their mouths. Prosecutor asks, "Is the wound survivable?" No. "Did you find signs of internal bleeding?" Yes. The prosecutor is showing a duplicate of the knife used in the stabbing. Is a knife like this considered a deadly weapon in Texas? Yes. What is the cause and manner of death? The result of a stab wound to the chest. The manner is homicide. Defense attorney steps in, as in the report and in the drawing, you list the wound as being obliquely oriented. She says yes, it gives a description that the wound was at an angle. The defense attorney says closer to horizontal. Yes. An exact depth of 2.5 inches. He also asked, do you have a way of establishing force use? She said no. Shook is approaching the medical examiner. Let's see. He also asked, would it be consistent if the victim was standing over the person stabbing, let's say in a bleacher? Witness says it can cause an angle going from back to front. There are many possibilities because the body is in constant motion that can be consistent. The prosecutor says that there's a lot of danger in reenactments like the defense just did. Prosecutors ask, is it's easy to construct a finding that fits what you want? She says yes. He then asks, I don't want the jury to think Austin Metcalf impaled himself on Anthony's knife. It's just probably right. Witness says yes. It's dangerous to make those kinds of assumptions. She said yes. The impaling is one of hundreds or thousands of things that could happen. She says yes. He asked her, can you explain what a defensive wound is? She said typically it's on their hands or forearms. He then asked, did you find any defensive wounds on Austin Metcalf? She said no. Let's see. First defense witness in Carmelo's case was his former track coach. Let me see. So Mike Howard called the football and track coach for Centennial. He says, how is track different from football? He says it's more of a player-driven sport. Is track more relaxed and leads to mingling than football? Yes. Are you aware of any policy of players not being allowed to go into other teams' tents? No. Kids will mingle and meet each other people and make new friends. Now, once again, I'm not victim blaming. I'm not saying what was done was right. I'm saying that It's not a crime to not go and mingle and be in other people's tents. We've done it. Now, is it advisable to stay in your own tent? Yeah, it is, but it's not a crime. Um, let's see. Defense asks, everyone who knew Carmelo called him Mellow. Yes. Defense is not referring to Carmelo as Mellow. He's showing a defense exhibit showing a plaque that lists the football captains for the year, showing Carmelo Anthony's name. Coach says captains are chosen by other players. Was a starting defensive back in 2024. Did his season end early? He suffered a significant shoulder injury that needed surgery. He wore his arm in a sling for a while, yes. Defense, I like to turn back to Carmelo. The jury has heard about Little M track meet in March, the Lobo Invitational. Did he participate in events? Yes. Now about the April 2nd meet at the Kirkendall Stadium. Defense, was the tent ready in your bus that day, the morning bus? No. Mello needed to be there in the morning for his events. Yes. Bill, the prosecutor, then asked, when is the last time you talked to Carmelo? The day of the event. You are aware there's no weapons allowed at track meets? Said yes. The prosecutor then asked, I imagine you don't approve of your athletes stabbing other athletes in the chest? Said no. Prosecutor asked, it shouldn't happen that one of your athletes end up in another team's tent? Yes, sir. Prosecutor asked, is there any reason an athlete should have a knife at the track meet? And he's showing the knife replica. He said no. Then the prosecution asked, you would expect someone asked to leave a tent to comply? He said yes. These are kids. They, my kids is good, never been in trouble. Do they listen? Not half the time. Let me see. Defense witness has a twin brother, fraternal, graduated from Centennial High, played football 4 years. And did you know Carmelo Anthony? What did you know him as? And this is defense asking another individual. He's 18. Yes, we called him Mello. How would you describe your relationship? I say we're friends. We hung out. How's track different from the football game? There are way more people and you can rock around. A part of a track is making friends. Would you agree with that? Did you have any friends from other teams? Yes. Did you spend time under other people's tents? Yes. Did you see other kids doing the same? Yes, sir. Did you ever have a problem doing that where you were told you shouldn't be doing that? No. Would you sometimes sit down and have a conversation? Would you spend more time in the tent? I spend some time. Have you ever been in Memorial Tent before? Yes. Was it to say hi or leave or spend time or hang out? We spend time hanging out. Was it just you? Me and Carmelo, we both had friends at Memorial. How much time did you spend? About 10 minutes. Were there any problems with that? No. There's no need for a knife at a track meet. And this is the prosecution now asking the witness. There's no need for a knife at a track meet. No. As far as you know, Frisco ISD policy of not having a knife at the track meet has never been violated. It hasn't. All right, let me see. Courtroom is full. We're waiting for judge and jury to enter. Prosecutors just motion Austin parents to follow them outside the room to discuss something. We don't know what it is. All right, first defense witness in Carmelo Anthony's case is a 17-year-old Centennial High School. He was a football and track teammate of Carmelo. He says Carmelo was acting normal in the stadium when their team arrived and sat in the bleachers of the Kukendall Stadium. Defense asks, would you agree with me that a football game is more of an our team versus our team culture? And he says, no, sir. What about track? Is it more social? I could agree. I definitely agree with that. What would you do to pass time? Witness says scroll on my phone, get food. They asked, what about spending time under other teams' tents? And he said, I don't think I've ever had done it, but it never crossed my mind like that. Have you seen, have you ever seen other kids who have done that? I can't put my finger on it. Wait, I can't put my finger on a time when I noticed it. Witness testifies that the Centennial track team was hanging out in the baseball dugout while waiting to determine if there was a rain delay in the start of the track meet. They had to leave and they didn't have a tent. He says they went out on the field to warm up. Defense says, what happens once you go out to the field and start to warm up? Witness says the rain had almost died down to a full stop and it started to pick up again. He says the team dispersed and Carmelo Anthony headed to the bleachers. Defense said or asked, what made you notice him in the bleachers? Witness says he just was looking around and I saw someone I recognized. He said he saw Anthony under the Memorial High School tent and it looked crowded underneath. Defense asked, describe what was happening. Everything looked completely normal. Defense asked, describe to the jury what you saw and what you thought. Witness says, I had looked up, and when I looked up, I heard a sound a lot like yelling. I hear louder voices over there, and when I looked over there, people weren't facing the field anymore, they were looking back. Defense says, do you remember telling the detective my teammate might be in trouble or maybe I need to go help him? Witness says, yes, sir. I thought there was something wrong. I wanted my teammates to see it too. Let's see. More testimony and cross examination. What did you see when you first noticed something was wrong? I saw the arms go out and I see arms and make contact with Carmelo. Can you see how much contact is being made with Melo? No, sir. Was that concerning to you at the point? Yes. You were sure that this was a fight, but you were concerned it could be a fight? Yes, sir. I was running through all the possibilities of it, where this was a friend or not. Did what did you do next? It got super loud and people started standing up and were like, what happened? So did you not see the stab or the moments before that? No. Mellow seated? No, sir. What happened next? I saw, what I saw was Austin pulling up his shirt saying he got stabbed. Do you see Mello at some point? Uh, do you see Mello at some point? What was he doing? Kind of a light jog going to the right of the bleachers. Did you see him when he stopped? He is crying, and there is a coach kind of comforting him. I'd say distraught is the best way to describe it. So it's saying that he was distraught at that time. Defense. Did it look like a put on? Witness said, I said everything going on was very, very real. You could hear him crying? Yes, sir. I heard him saying, I told him not to touch me. Defense says, how was he? Distraught? Yes, very distraught. Defense says, you didn't see large parts of what happened under the tent. Is that fair to say? Witness says, yes, sir. The prosecutors cross examine. The state asked, you had a few things wrong when we talked back in April. Is that right, sir? Yes, sir. Prosecution, your initial statement to the police said that you saw Carmelo Anthony surrounded, so it had to be after the stabbing. Yes. You had a story in your head when we visited, correct? Yes. And when you saw the video, your eyes were opened to what actually happened. Is that right? Yes. My impression when we first met you, you thought when you saw people surrounding Carmelo Anthony, it was before the stabbing. Yes, sir. That was actually after the stabbing? Couldn't tell. When you and I met, you told me you thought it was before the stabbing. I thought it was as the stabbing was happening. You know you're wrong. Yes, sir. Wow. No objection there? That's crazy. Prosecutors show videos showing the witness on surveillance video from the stadium that revealed the witness was on the field, not looking at the Memorial High School tent at the time of the stabbing happened. Have you learned how your mind can play tricks on you? Yes, sir. You didn't have a knife on you? No, sir. Have you ever been under another team's tent? No, sir. If you had been under another team's tent and they asked you to leave, would you? Yes, sir. I redirect. The defense then asks, I think you described people in a U shaped around Mello. Yes, sir. Who we? Frisco police officer Riley is next witness. He interviewed some of the witnesses in the field house near the football field. One of the witnesses was a memorial track athlete who knew Carmelo Anthony and talked to him under the tent. He reviewed the cell phone of the student to check his camera roll and text messages and Snapchat account. Defense. Did that examination take 30 to 40 minutes and try to find anything interesting or relevant? I would describe the consent based search as being thorough. Defense attorney is getting officer to confirm that the knife was legal to carry in Texas and into stadiums. Defense. It would surprise you if schools have policy against such things. No, it would not. Witness was excused. Defense called another 17-year-old from Frisco High School. He's on the football team and on the track team, and he was on Frisco track team at the meet on April 2nd. 2nd, sorry. Defense. How is the culture around the track meet different from a football game? They're really social, so everybody would know each other, see each other, say hi, really social. Defense. Is that only on the field or only in the bleacher? How would you describe it? It's all over the place. Did you ever had other kids from other tents come over to your tent and say hi? Yes, sir. It wouldn't hurt to say hi. Defense, do you recall where you were in the stadium? Yes, I was by the gates. Did anything happen that you particularly noticed of into in the stands? Everybody was standing up and I saw somebody get pushed or getting punched. I don't know which. Is that under the memorial tent? Yes, sir. So it looked like to you that it was kind of under the tent. Yes, sir. Do you remember saying that it looked like somebody was trying to stop a fight? Yes. The person who got punched or hit, did they react in any way? I don't know. Did you see him, Carmelo, make a swing type motion? Yes, sir. What happened after that? I saw he did a swing motion down and I heard, oh my God, somebody just got stabbed. And people just started scattering. You got a very small snapshot of this. Is that fair? Yes, sir. Is it fair to say you don't remember? Yes. A lot of what you're saying, you're kind of guessing. Yes, sir. Do you remember seeing the video I showed you? Yes, sir. It showed that you didn't see what you thought you saw. Yes, sir. And okay, so when it says, is it fair to say that you don't remember? That's when the prosecution came in and started asking questions. And the prosecution ended with this. I'm not trying to put you on the spot. It's fair to say after seeing the video, you didn't want to testify. We wanted to do the right thing. The judge has ordered an unexpected. Okay, that was a lunch break. Da 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 da. All right, so let's go on. They said lots of speculation from the court watchers that I won't go into. But as soon as we are allowed back inside, I will let everybody know. Mm. All right. Jury was dismissed. Closing arguments. That was June 8th. Breaking. The defense has rested in the Carmelo Anthony's trial. The scene outside. Defense. Okay. So the defense objected to the jury charge before closing arguments begun. They are citing provoking the difficulty instruction under the penal code. This is related to the self defense argument and provocation. Prosecutors argued against defense objections, saying that a rational jury can find there was a provocation, a lack of defensive wounds, defendant's comments, and a folding knife that was open. Judge overruled defense objections and another objection that the jury charge will not include criminally neglect homicide as a possible lesser offense. They were allowed to consider manslaughter. Closing arguments was 35 minutes each. Let me see. All right. And so the prosecution waived the right to open. So the defense started the closing argument segment. Austin Metcalf had no legal right to use force to eject Carmelo Anthony from the tent. He had no legal right to put his hands on Carmelo. Carmelo is in a public place. We asked you this incredibly tough task, which is to follow the law. The government wants to make the case about Melo could have just left. You heard that the track event is a social event. It was completely common for kids to be milling about and go by and say hi, stop into the tent. We know that it was raining. I don't know why we have to have this argument about whether it was raining. We know how Texas weather is, so it's easy to think, boy, I better get out of the rain. He says a witness testified, we had no problem with him under the tent while it was raining. You have to put yourself in Carmelo's shoes, so you start under that tent. You want to get out of the rain. Sure enough, one of the people at Memorial says, yeah, come over. Then all of a sudden, Hunter Metcalf or Austin say, who are you? You need to leave. These guys are much bigger than you. You don't turn your back and walk away and take a chance that these teenage boys with their raging hormones. Austin and Hunter had the right to tell Mello to leave, but they did not have the right to use deadly force to make him leave. Mello had an absolute right to defend himself against that. How do you know in a split second of chaos when it's too late? Because it what because if you wait too late to defend yourself, self-defense is meaningless. That was his closing argument. We heard a lot of differing accounts from the kids who were under that tent. I know it's obvious, but let me just say it. Every single one was a Memorial kid. He should be on guard for having a bias because of course they would. Austin was their leader. So we heard a very jumbled account of really what really happened in that tent. It was a shove, it was a hit, it was a lineman drill. On Anthony leaving the scene, not exactly escaping like the guilty do, Mello had every opportunity to go right out that exit. We heard about Mello's emotions. Every single person who saw him down on the track said he was crying. What did he say? Mello said, he's not gonna die. It's clear he stabbed him in a place that he was not going to die. Austin reportedly said to Carmelo, according to the witness, if you don't move, I'll beat your ass. As much as we not like it, even a 17-year-old kid can legally have a 5.5 knife, even in high school stadium. Yes, it's a violation of policy, but it is not a crime. Texas law does not require that you wait until you get hit. So ask yourself, has the government ruled out reasonable doubt when you put yourself in Mello's shoes under that tent? You didn't hear the words motive in the jury charge, but you can make reasonable deductions as to how that applies to intent. Carmelo has no motive other than he absolutely felt like he was in danger. The evidence is very clear these kids didn't know each other. The case is not about race as much as people want to make it about that. There is no evidence that Carmelo do anything but really thinking he was defending himself in that split second of chaos. He says the way that the knife enters shows that it wasn't intentional. He says Carmelo's hand was underneath the knife, not on top of it. On credibility of memorial students who testified, I understand whether they are coming from. They lost their brother. On why Carmelo didn't walk away. If you turn your back on him, who knows what happens? We have this course of people, but it's too late to turn your back. What's going to happen? I don't know. On Carmelo keeping his hand in his bag. You don't have something in your bag. I do have something in that bag. On the touch me and find out comment from Carmelo, that is the ultimate warning, is the ultimate back off. I don't know if that's the closing argument of the prosecution or the defense. Oh, okay. Okay. Yeah, that was weird. Let's see. From Bill on Carmelo's touch me comment. Do not let them turn threat wait. Do not let them turn threat into a warning. You heard the testimony. You know it was a threat. It wasn't a warning. Let's see on the defense testimony that Austin could have stabbed himself. Okay, that's ludicrous. What should be important is mindset. He took a knife to attract me. He was going to come out on top of any hostile encounter. That's mindset. There is one of those rare cases where every important fact could be boiled down to one sentence. You do not have you do not get to meet a shove with a stab, especially if you provoke the shove. It's crystal clear that facts are simple. You don't get to meet a shove with a stab, especially if you provoke the shove. They said he was confused because the twins were coming at him again, trying to turn the threat into a warning. There was no fuse on this thing. They went from 0 to 100 like that. Thank goodness we have the video. The video tells the story. Why didn't he just walk away? You see, he had a choice to walk away and abandon the encounter. On whether manslaughter would apply in this case instead of murder. If you think AM impelled, Austin impaled himself on Carmelo's knife, find him guilty of manslaughter all right, as far as the witnesses, all said Carmelo Anthony provoked it. Why self defense doesn't apply? The prosecution stated that you can meet deadly force with deadly force in Texas, but you can't meet force a shove with deadly force, a stab. Size differential, it doesn't work in this case. You don't get to kill someone because they are bigger than you. Self defense had to be a reasonable belief. A reasonable belief means a belief that would held by an ordinary and prudent person in the same situation as the defendant. It has to be immediately necessary when there was immediate necessity to plunge a knife into an unarmed young man. It's not self defense, folks. It's murder. Murder, plain and simple. The one standing up, no one surrounded Carmelo Anthony. The memorial kids hadn't turned on him. The video was so important you could see with your own eyes how normal that day was. At some point when he reached into the bag, he opened it and had it all ready to go. Did Austin Metcalf have defensive wounds? No. He never saw it coming. If this case was really about a young man trying to stay out of the rain, get under the bleachers. Let's see, on why he ran for an exit instead of a coach. It is guilty mindset. He touched me. He did this. He did that. What would he have said if he was really confronted by both twins? His words alone believe the fact that this was one on one. This was not a mob of memorial kids. Reciting a witness who testified about Carmelo's behavior. He had in his mind what he was going to do. I'm not going to fight you, Austin says multiple times. One of the witnesses who knew about Austin and Carmelo. It wasn't a hard push, it was a small shove. Carmelo was trying to prove that he could do a violent act. Well, he sure did, folks. He sure did. I told you the exact same thing. It's not self-defense. Austin didn't want to fight. It's a tragedy for everyone involved that there's a lot of truth in that outside this courtroom. It's not a tragedy for Carmelo Anthony, it's a tragedy because of the decision he made. It is senseless that Austin lost his life on a Wednesday morning at a high school track meet. We don't take weapons to school events, but he did. Ultimately, this case is about accountability. What kind of community do you live in? You represent the community today. As unpleasant as it may be, it's your duty to follow your oath and hold this young man accountable for his senseless murder. I beg you to make justice swift in this case. Closing arguments were over. The judge gave the jury the instructions to the alternate jurors. All right. All right. And I read the jury charges. And this is where and that was breaking. So the jury, after deliberating, found him guilty of murder. He broke down in tears. I'm sorry, y'all. I'm reading. Hopefully, y'all reading right now too. J.D. Miles' report punishment phase ended abruptly after one witnessed Carmelo Anthony's mother. Both sides rested after waiving opening statements. Anthony's mother: "He's my oldest. He's my firstborn. He will always be my baby. I love him so much." The defense says, "Does your son regret what he did?" Anthony's mother stated, "Yes, he's very sorry for what he did." Punishment phase just ended after one witness, two questions from the defense, and one from the prosecution. The judge will work on charge. The jury has been deliberating in the sentence more than an hour. He faces 5 to 99 years in prison, but defense attorneys are asking the jury to consider sudden passion. It is a factor that can lower the sentence range from 2 to 20 years if they decide that the murder was provoked by the victim. And then it states that they found has sentenced him to 35 years in prison for the murder. Yeah, that's it. And shortly after, he was transferred out of the Collin County Jail to TDCG. That is the replica. And I have that exact same knife. I use it for fishing. You know, I heard about I didn't watch it, but I heard the comments and I really can't say that they were justifiable. I went over I'm gonna stop sharing. I went over what was it? Oh yeah, the Denton County. I'm sorry, I just went blank. I went over the Denton County with Alec Adamson, the individual who was charged 4 years. Well, he was charged, so the murder charge got reduced to aggravated assault. He was sentenced to 4 years. The mother stated, and they asked her how she feels, and as a mother, I can't begin to fathom losing a child for one. But she still had compassion. She still said that she does not want to see that child, live the rest of his life in prison. How she felt about it, it was still fresh. You had to give her time, but there was no hate in her heart. She didn't call him out his name. Um, I need to post that article, but that's Denton County, a little bit more liberal. They still conservative, but not as conservative as Collin County. But just to see all of the clips from what Austin's, you know, father said was mind-boggling. There was no need to call that. We will never get back to a I don't even know if it was ever to a place where there wasn't any racism. But I hate that when I have to leave this earth, my children will be here. I hate knowing that one day they're going to encounter not this particular situation, but they're going to encounter something where they have to think for themselves, they have to defend themselves, whatever the case may be. No parent should have to bury a child. No parent should have to lose their child to a system. What Carmelo did was wrong. Did he wake up that morning saying this is what he's going to do at the track meet? No. Why was he carrying a knife? The same reason people carry a gun in the state of Texas. I carry a knife going to go walk because you never know what happens. You never know what happened. But based off the jury instructions, they had to base their verdict on the evidence that they viewed in court and with the witness statements. We saw the videos, we can't really tell what was going. We see some commotion and we see somebody running. I read the statements or the testimonies based off of what Mr. JD Miles, the news reporter in Dallas, he's all over Texas. He reports on a lot of things. I find him as a credible person I can get my information from. But based off those statements, some of them were contradicting. Probably two of those witnesses say they knew him. They even called him Mello. But in the 911 call, when asked, does anybody know? And it could be that the person who made the 911 call didn't know that an individual actually knew Carmelo. We don't know. But it was very contradicting when people are saying they didn't know him, but yet they call him Mello. They knew both Austin and they knew Carmelo. But to say all of this, that's neither here nor there. The jury did what they was instructed to do. As far as the sentencing of 35 years, that was harsh. That's 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 uncalled for. And it's not fair. It is not fair when we see all of these murders. Now I'm going to say murders because I'm comparing it to other murders in other counties. We are seeing in North Texas individuals that don't look like us get lesser time. Now, one I talked about the county could just be the county that you're living in. Collin County just ain't it. Dallas County has fairness to it. Because with Amber Geiger, we was like, okay, what's going on? She delivered like it. I can't compare it, but I mean, here you have a lady that says that she thought she was walking into her apartment and shot somebody. I can't say that was premeditated. I don't think she said, "Okay, today I'm just going to walk in the wrong apartment," and, they gave her 10 years for that. Or the case in Denton County where the young student drove from Prosper to Lil M to make a deal. He thought he was going to get robbed and he powed and murdered a 19-year-old. The jury found compassion, lowered it to an aggravated assault, and he got 4 years. But here we are, Collin County, predominantly white, conservative. It's not a lot of people say it's not about race, but you have a black man with an all-white jury. What else are we supposed to think? Like 30, 35, and I don't impose death penalties unless you are a pedophile. If you are a pedophile, you need the death penalty. Do I think that 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 sentence was harsh? Yes, I do. Compared to all of the other cases that I have seen in the Metroplex. I know each county has their own jurisdiction. I see that. But within the county itself, and this is facts because I looked it up, there's truth to it. Black, brown, any minority have harsher sentences than our counterparts. And that is a true fact. I look at the lawsuit against the district attorney in Collin County, employment discrimination, retaliation, sexual assault. Like, how do you treat women? How do you treat somebody that does not look like you on a state level? Because these are district attorneys. So I just wanted to bring to you guys as awareness as far as what the jury was instructed to do. It was plain and simple. They had so everything that we saw, they seen, plus more. So they had to take what they saw, the evidence, the videos, the 911 call, the witness. There was what they say about 20 to 30 witnesses that were called, 21. Can't remember the exact number, but I know it's more than 20 that took the stand. And they had to take all of that in consideration. And based off of the jury charge, the jury instructions, they had to determine whether his actions, whether he was guilty of murder or guilty of manslaughter. What I took away is him pushing him did not warrant for a deadly weapon. It would have to be a deadly weapon against a deadly weapon, and then that would have been one thing. But to somebody who did not have a deadly weapon, that raises another question. So was Karmelo right in taking that knife and stabbing him? No, he was not. The issue is the sentencing. 35 years is harsh compared to other murders in that county and the surrounding areas. Y'all let me know what y'all think. Don't forget to like, share, and subscribe. Please leave your comments in the comment section. Be respectful, be kind. Everybody's entitled to their opinion, but no need for name calling and cussing each other out. Okay? Until then, you all have a blessed night. I'm out. Bye.